Good afternoon, everybody. So we're going to crack on into part two, looking at the second half of Judge David Hamilton's majority decision. Just before I get onto that, just let you know that things are starting to come together nicely in preparation for Marathon, which will be in just a week and a half's time. So looking forward to that. Anyway, let's crack on straight into. I believe we were about to start page 22. Here we go. Let's do that and do that. So it fills up the whole of the screen, and then I think we go to this button here. Yeah, I'm pretty sure that's. Hello, Linda. Yes, I'm pretty sure that's where we got to. Is that right, Lyndon? Page 22. I'm sure this is where we were up to. So David Hamilton carries on, and rather interestingly points out that at trial, Dassey testified and denied any knowledge of or involvement in Teresa Holbach's murder. He did not try to explain what he had meant by telling his mother, "Not really," and "they got to my head." According to his lawyer's version of events, Brendan came home from school at 3:45 on October 31st and played video games until having dinner with his brother and mother. After the others left, Dassey claimed he fielded a phone call from his brother's boss, and then shortly after that, a call from Stephen Avery. At about 7-ish, Brendan Dassey claimed he joined Avery at the bonfire, making 4 or 5 trips around the salvage yard, picking up discarded items to throw on the flames. Around 9 o'clock, Dassey helped Avery clean up a spill in his garage, and after a phone call from his mother, Dassey claimed he returned home around 9:30 or 9:45. According to his trial testimony, none of the incriminating events related to his March 1st conference ever happened. And yeah, he's consistently stood by that account of what happened, because David Hamilton, that is exactly what did happen. Anyway, D, the state court's treatment of Dassey's confession. Before trial, Dassey moved to suppress his confession as involuntary. After briefing and a hearing, the trial judge stated detailed findings of fact in an oral ruling. Sup-app, whatever that means. So, the judge, C. Jerome Fox, noted Dassey's age and observed that he had an IQ level in the low average to borderline range. The judge noted that school records showed that Dassey was in regular track classes but had some special education help. The judge also noted Dassey's lack of a criminal record, the non-custodial nature of the February 27th and March 1st interviews, as the parties had stipulated, and Dassey's Miranda waivers from both days. The judge found that Dassey knew he could stop answering questions, and he knew he could leave the room at any time on February 27th, and that he repeatedly indicated his continuing interest in speaking with the police on March 1st. The judge found that both Dassey and his mother consented to the interview on March 1st. The judge also quoted several of the investigators' admonitions to tell the truth, including "Honesty here is the thing that's going to help you," and "Honesty is the only thing that will set you free," upon which Dassey relies so heavily now. Throughout the interview, the judge found the investigators had used a normal speaking tone with no raised voices, no hectoring or threats of any kind. Nothing on the videotape visually depicts Brendan Dassey as being agitated, upset, frightened, or intimidated by the questions of either investigator, and he displayed no difficulty in understanding the questions asked of him, the judge found. Though at times prodded to be truthful, at no time did he ask to stop the interview or request that his mother or a lawyer be present. The admonitions, the judge found, amounted to nothing more than a reminder to Brendan Dassey that he had a moral duty to tell the truth. The judge also found that Dassey was not coerced by the interviewers, occasionally pretending to know more than they did, because they did not interfere with his power to make rational choices. And finally, the judge found that no frank promises of leniency were made by the interviewers of Brendan Dassey, and that he was in fact flatly told, "We can't make any promises." On the basis of these findings of fact, given Dassey's relevant personal characteristics and applying a totality of the circumstances test, which I'm using here, the judge found that Dassey's admissions in the March 1st interview were voluntary statements and denied Dassey's motion to suppress. The March 1st confession was the most incriminating evidence at trial. The jury found Dassey guilty on all charges, participating in rape and murder and mutilation of a corpse. In August 2007, Dassey was sentenced to life in prison. Dassey filed detailed motions for a new trial in 2009, and the same trial court held 5 days of hearings on those motions in January 2010, probing Dassey's claims that his attorneys rendered ineffective assistance. A 3-judge panel of the Wisconsin Court of Appeals affirmed Dassey's convictions, finding that his confession was voluntary and any ineffective assistance was not prejudicial. The Court of Appeals used the trial court's findings of fact to summarize the circumstances of the March 1st confession and Dassey's claim that it was involuntary. The court then cited the legal standard for such claims, the totality of the circumstances, as applied by leading Wisconsin state cases. These cases, particularly Gerald, 2005, cited and discussed several of the leading precedents on voluntariness from the United States Supreme Court. The Court of Appeals cited Gerald for the principle that a voluntariness analysis involves a balancing of the defendant's personal characteristics against the police pressures used to induce the statements. Wisconsin law uses a clearly erroneous standard for appellate review of trial court findings or voluntariness. After summarizing the trial court's findings, the Court of Appeals concluded, the court's findings are not clearly erroneous. Based on those findings, we also conclude that Dassey has not shown coercion, as long as investigators' statements merely encourage honesty and do not promise leniency. Telling a defendant that cooperating would be to his or her benefit is not coercive conduct, nor is professing to know facts they actually did not have. The use of deceptive tactic like exaggerating strength of evidence against suspect does not necessarily make confession involuntary, but instead is factor to consider in totality of circumstances. The truth of the confession remained for the jury to determine. The court went on to reject Dassey's claims that his pre-trial and trial counsel provided ineffective assistance. The Wisconsin Supreme Court denied Dassey's petition for review. Dassey did not file a petition for certiorari in the United States Supreme Court. Well, not yet, he hasn't. Federal habeas corpus review. Dassey filed a federal habeas corpus petition in the Eastern District of Wisconsin in 2014. In a detailed opinion, the district court granted habeas relief, finding that the false promises of leniency were indeed made to Dassey and that his March 1st confession was not voluntary. A divided panel of our court affirmed that decision. We granted the state's petitioned to rehear the case en banc and now reverse with instructions to dismiss Dassey's habeas petition. I think he's kind of gone very briefly over the two findings in Brendan's favour. Applying the EDPA standard, voluntariness under 2254. The state court decision that Dassey confessed voluntarily was not an unreasonable application of Supreme Court precedent. The state appellate court drew on fairly detailed findings of fact, which were not clearly erroneous, and provided a terse but sufficient explanation of why the trial court's decision was a reasonable application of the broad totality of the circumstances test. Yeah, terse. I would take issue with that. There was basically nothing. So it wasn't just brief. Factors pointing in opposite directions. A number of relevant factors we recognise tend to support Dassey's claims about the March 1st confession. He was young. He was alone with the police. He was somewhat limited intellectually. The officer's questioning included general assurance of leniency if he told the truth, and Dassey may have believed they promised more than they did. At times, it appeared as though Dassey simply did not grasp the gravity of his confession. Well, David, that's an amazing bit of thought from you there. Fancy that, you know. No wonder you're a judge. After confessing to rape and murder, he asked the officers if he would be back at school that afternoon in time to turn in a project. Portions of the questioning also included leading and suggestive questions, and throughout the interrogation, Dassey faced follow-up inquiries when the investigators were not satisfied with what he had told them, leading him at times to seem to guess. In addition, the confusion and contradictions in Dassey's account of the crimes of October 31st lend support to the view that his confession was the product of suggestions and or a desire to tell the police what they wanted to hear. David Hamilton, are you suggesting that there's even a little bit of doubt in your mind? Who gets the benefit of that doubt? At the same time, many other factors supporting the finding that Dassey's confession was indeed voluntary. As I say, there's still plenty of doubt, even in, I believe, in Hamilton's mind. Start with the circumstances of the interrogation. As stipulated by both sides, Dassey was not in custody when he admitted participating in the crimes of October 31st. He went with the officers voluntarily and with his mother's knowledge and consent, although there's a bit of dispute about that, I believe. He was given Miranda warnings and understood them sufficiently. The interrogation was conducted during school hours and in a comfortable setting. Dassey showed no signs of physical distress. He had access to food, drinks, and restroom breaks. The interrogation was not particularly lengthy, especially with the breaks that were taken every hour. Dassey was not subject to physical coercion or any sort of threats at all. Given the history of coercive interrogation techniques from which modern constitutional standards for confessions emerged, this is important. The investigators stayed calm and never even raised their voices. As the Wisconsin courts found, there is no sign that Dassey was intimidated. Turning to the techniques used in the interrogation, the investigators told Dassey many times that they already knew what had happened when in fact they did not. Such deception is a common interview technique. To our knowledge, it has not led courts, and certainly not the Supreme Court, to find that a subject's incriminating answers were involuntary. Fabricating a co-conspirator's confession is relevant but insufficient in our view to make this otherwise voluntary confession inadmissible. Citing Fraser versus Cupp. Also, most of the incriminating details in Dassey's confession were not suggested by the questioners. Really? I think we might take issue with that. He volunteered them in response to open-ended questions. I think we're going to have a somewhat more truthful and different story coming soon, Mr. Hamilton. When Dassey's story did not make sense, seemed incomplete, or seemed to conflict with other evidence, which was basically all the time, the questioners pressed Dassey with further questions. Those techniques are not coercive. Dassey responded to such questioning by modifying his story on some points, but he stuck to his story on others. Those passages support the view that he was not being pushed to provide a false story against his will. For example, Dassey resisted repeated suggestions that he had participated in shooting Teresa. He denied repeated suggestions that he and Avery had used wires and cables in the garage to restrain or harm her. In one telling instance, the questioners tested Dassey by falsely telling him that Teresa had a tattoo on her stomach and asking him if he had seen it. He told them no. That is simply wrong, Mr. Hamilton. You need to check up with Mr. Ericosi. He will put you right. In fact, if you ask him nicely, he might even send you one of his t-shirts. When the questioners pushed harder, he was not willing to say he knew that they were wrong, but he stuck to his recollection that he had not seen a tattoo. Completely and utter false, Mr. Hamilton. Brendan was quite happy to say that she had a tattoo. When asked, do you disagree? He said no. That means he's agreeing. And I don't know what it was. He certainly didn't say, I don't know where it was. They'd already told him that she had a tattoo on her stomach. So why would he use the word where it was? It was what it was. Anyway, carrying on. Under EDPA, the essential point here is that the totality of the circumstances test gives courts considerable room for judgment in cases like this one, where the factors point in both directions. Given the many relevant facts and the substantial weight of factors supporting a finding that Dassey's confession was voluntary, the state court's decisions was not an unreasonable application of Supreme Court precedent. This view is similar to Yarborough versus Alvarado, where the Supreme Court applied EDPA to a state court finding that a 17-year-old suspect had not been in custody when he confessed to murder. The custody question was governed by a similarly general totality of the circumstances standard. The Supreme Court summarized the array of factors pointing in opposite directions, in custody or not in custody, emphasizing that the more general the rule, the more leeway courts have in reaching outcomes in case-by-case determinations. The Supreme Court found that the state court finding was not an unreasonable application of binding precedent. These differing indications lead us to hold that the state court's application of our custody standard was reasonable. The Court of Appeals was nowhere close to the mark when it concluded otherwise. The terse state court opinion. Dassey criticizes the Wisconsin Appellate Court's decision for having been too terse, addressing the confession in just 2 pivotal paragraphs. The relative brevity of that part of the opinion is not a reason for granting habeas relief. Given the volume of words that federal judges have devoted to this case, one might assume that the totality of the circumstances test requires courts to detail at length the weight they have assigned to all factors and how the presence of one factor affects the rate or relevance of other factors. That assumption would be incorrect. The Supreme Court itself has issued terse final determinations on voluntariness after a recitation of relevant facts. It has ruled on voluntariness by simply adopting the reasoning of other courts. 2254 does not authorize federal courts to impose mandatory opinion writing standards on state courts. State court decisions receive significant deference, even if they provide no reasons at all. So, Whatley versus Zateki. In this case, the state appellate court endorsed detailed findings by the trial court that provided substantial support for the finding that Dassey's confession was voluntary in the eyes of the law. 3. Juveniles in special care. The requirements that courts take special care in analysing juvenile confessions does not call for habeas relief here. The state appellate court met the requirements for analysing juvenile confessions by considering Dassey's age, his intellectual capacity, and the voluntary absence of his mother during the interrogation. The state court noted that the officers read Dassey his Miranda rights and that Dassey later remembered his rights and agreed to talk anyway. The court assessed coercion in relation to Dassey's vulnerabilities, including his age, intellectual limitations, and high suggestibility. The court did not limit its inquiry to only whether the most abusive interrogation techniques were used. The court examined the tones and volumes of the investigators' voices, finding that the officers used normal speaking tones with no hectoring, threats, or promises of leniency, though they did prod Dassey to be honest and sought to establish a rapport with him. The court even considered Dassey's physical comfort by noting he sat on a sofa and was offered food, drink, and restroom breaks. Precedent. Dassey simply has not pointed to Supreme Court precedent that mandates relief under these circumstances. Even in cases where deferential review under AEDPA does not apply, the Supreme Court has not found a confession involuntary in circumstances like Dassey's March 1st confession. Consider Bolden versus Holman from 1969. The defendant there was an 18-year-old, had an IQ of 83, suffered from an anxiety complex, and was susceptible to coercion. He was interrogated for less than 3 hours after being told that he had the right not to make a statement and that any statement might be used against him. He was treated courteously and allowed to eat, smoke, and to use the toilet facilities. Though 2 years older than Dassey, Bolden was apparently still dependent on his parents. Other facts of his interrogation were more troubling than those in this case. Bolden was interrogated from 10 p.m. until after midnight after several hours in custody. Police had denied Bolden's father access to him, and after Bolden asked whether he was supposed to have a lawyer, the police said he would not get one until he talked. The Supreme Court determined that although the issue is a relatively close one, the conclusion was justified, that Bolden had confessed voluntarily. In Fair versus Michael C., the court again ruled a juvenile confession was voluntary. Like Dassey, Michael C. was 16 years old. He claimed that the police made promises and threats during the interrogation in the hope of obtaining leniency for his cooperative attitude. Michael C. indicated that his pleas to stop the interrogation were ignored. He also claimed he feared police coercion and pointed out that he wept during the interrogation. Despite these assertions, the court determined that Michael C.'s claims of coercion were without merit. Unlike Dassey, Michael C. apparently did not have a low average to borderline IQ, and Michael C. did have significant prior experience with the criminal justice system. Though the presence of those factors may have provided room for Dassey to argue on direct appeal that Michael C. should be distinguished. They do not show that the Wisconsin court's decision here was unreasonable within the meaning of 2254. As in Michael C., the police here indicated that a cooperative attitude would be to the suspect's benefit, but their remarks in this regard were far from threatening or coercive. In reviewing these cases, we remember the Supreme Court's admonition that determining whether a confession is voluntary requires more than a mere colour matching of cases. But like the court, we find these comparisons helpful after careful evaluation of all the circumstances of the interrogation. In Mincy, finding comparison to analogous cases not inappropriate when determining voluntariness. EDBA would be undermined if habeas courts introduced rules not clearly established under the guise of extensions to existing law. To be sure, this line between application and extension of existing law blurs when new factual permutations arise. The cases show, however, that the Supreme Court has considered and rejected claims similar to Dassey's, and Supreme Court cases do not require relief here. The Wisconsin courts did not apply the law unreasonably in finding that Dassey's confession was voluntary. Factual findings under 2254. Dassey also argues that he is entitled to relief under 2254 on the ground that the state courts made an unreasonable finding of fact, that the questioners made no false promises of leniency, affirming the trial court, which found no frank promises of leniency were made. The Wisconsin Court of Appeals determined that the investigators' statements merely encouraged honesty and did not promise leniency. Dassey's argument that this finding was unreasonable focuses on two things: his intellectual limitations and the spots in the March 1st interrogation where he claims the investigators implied that he would not even be arrested if he told the truth. We reject this argument. Because the Wisconsin Appellate Court accepted the trial court's findings of fact, we review the trial court's factual determinations directly. See another case in 2006 indicating that EDPA review and deference in such a situation should extend to state trial court findings. The trial court here highlighted the key points for both sides, including the warning that the questioners could not make promises, which supports the state here, and the problematic assurance that honesty was the only thing that would set Dassey free, which helps Dassey's claim, especially in light of his limited intellect. Whether we treat the state court's decision on this point as a finding of fact or a conclusion of law, we find nothing unreasonable about it. As noted above, the Supreme Court has not treated general assurances of leniency in exchange for cooperation or confession as coercive. To the extent precedents from other courts might be helpful in understanding a state court's factual findings, the cases signal that such general assurances are not legally relevant facts for determining whether a suspect's will was overborne and a confession was involuntary. Again, see some various cases: 09, 2016, 2014. We've got there a 2010 case, a 2001, and a 1990 case, in which the policeman is not a fiduciary of the suspect. The police are allowed to play on a suspect's ignorance, his anxieties, his fears, and his uncertainties. They just are not allowed to magnify those fears, uncertainties, and so forth to the point where rational decision becomes impossible. The State Appellate Court should be understood as having said that the investigators made no legally relevant false promises to Dassey. The District Court, the panel majority, and our dissenting colleagues have reviewed the interrogation differently, finding psychological coercion through a form of operant conditioning, where different investigative techniques combined to convince Dassey that the police had agreed to end the interrogation and to grant him leniency in exchange for confessing. As the panel explained, in its view of the interrogation, the investigators offered Dassey multiple assurances and sounded the theme of truth leads to freedom, culminating in the direct promise, honesty is the only thing that will set you free. The state courts did not view these tactics the same way. Their view was not unreasonable. The state court saw and read, as we have, exactly what the questioners told and asked Dassey in the interview and how he responded. EDPA leaves room for reasonable disagreement between state and federal courts. Disagreement on a particular judgment call does not show that the state court found the facts unreasonably. In denying Dassey's suppression motion, the state trial court weighed the same statements that concerned the district court and the panel. The judge quoted 4 separate instances where investigators prodded Dassey by stating that honesty would help him, and the judge noted that these were but a few examples of admonitions to be honest. The state court also recounted 4 quotations and other similar statements where investigators assured Dassey that they were behind him and in his corner. It viewed these statements as an attempt to achieve a rapport rather than frank promises of leniency. These findings are reasonable and consistent with the evidence and the relevant law. Habeas review does not permit us to use a set of debatable inferences to set aside the conclusion reached by the state court. Police best practices and the law. The concerns expressed by our dissenting colleagues and the district court about the potential coercive effects of the police tactics here are understandable. Critics of Dassey's interrogation see evidence of fabrication through the confessions, inconsistencies, and lack of solid corroborating physical evidence. Some of the confessions' inconsistencies are startling, particularly Dassey's shifting answers on the location of the shooting, outside the garage, on the garage floor, and in the car inside the garage, and his failure to recall consistently the order of attacks in the bedroom, stabbing, hair cutting, and throat slicing. Also during the dialogue about Teresa's shooting, the investigators prodded Dassey and injected some critical facts into the discussion that corroborated evidence they already knew. The state courts did not address these factual inconsistencies or the alleged lack of corroborating evidence, though it is not clear how they should have approached the question, if at all. United States Supreme Court precedent on this point is not unequivocal. In Blackburn versus Alabama, 1960, the court considered the unreliability of the confession in determining that a mentally ill defendant's confession was not voluntary. The very next year, the court indicated that the reliability of a confession has nothing to do with its voluntariness, because extrinsic evidence that a confession is true can confound the inquiry into whether a defendant's will has been overborne. The law later seemed to signal another direction, writing in Colorado versus Connolly that whether a confession is reliable as distinct from voluntary is a matter to be governed by the evidentiary laws of the forum. and not by the Due Process Clause of the 14th Amendment. Analysis of a confession's reliability as part of the totality of the circumstances may survive the instruction in Connolly, but it is not unreasonable to interpret Connolly as foreclosing, or at least not requiring, this line of inquiry before trial. We cannot fault the Wisconsin courts for failing to measure the inconsistency of Dassey's confession in this extent. In addition, the contradictions as to some details do not necessarily undermine the reliability of the core incriminating admissions. And he's actually quoting himself from the previous hearing. The concerns about reliability echo the opinions of scholars who believe that certain interrogation tactics tend to produce false confessions. Some police departments and experts have acknowledged this criticism and have changed their interrogation practices in response. We must note, though, that some of the interrogation tactics used in this case, like the repeated challenges to explain details that seem implausible, reflect practices advocated by such reformers. Well, we've looked at Saul Kassan in the past. He's obviously done a book or a report interviewing suspects, practice, signs, and future directions, describing as non-coercive the practice of investigators challenging suspects' accounts, often by pointing out contradictions and inconsistency. Again, Saul Kassan, The Psychology of Confessions, in another review, favouring interrogation technique where investigators address discrepancies that may appear in the suspect's narrative account to determine if the suspect is fabricating. These debates over interrogation techniques have not resulted in controlling Supreme Court precedent condemning the techniques used with Dassey. Absent a clear declaration from the court, we may not create new constitutional restraints on habeas review. Circuit precedent does not satisfy 2254, nor, of course, do state court decisions, treaties, or law review articles. Ineffective assistance of counsel. Finally, Dassey has also pursued his separate claim that his original lawyer provided ineffective assistance of counsel on the theory that the lawyer was operating under an actual conflict of interest prohibited by Kyler versus Sullivan. On this point, the state and federal courts have agreed. The Wisconsin Appellate Court rejected this claim. The district court also considered his claim carefully and rejected it, citing the limits placed on Sullivan claims by Mickens versus Taylor. We agree for substantially the reasons set forth by the district court. In this case, there was no actual conflict. Of interest and no multiple or concurrent representations that could have resulted in an actual conflict of interest. Given the state court's reasonable findings of fact and the absence of clearly established Supreme Court precedent that compels relief for Dassey, the district court's grant of habeas relief is reversed. The case is remanded to the district court with instructions to dismiss the petition. So as I was saying earlier, we're now up to page 40. Let's save that one for tomorrow. It's not the greatest reading in the world going through Judge Hamilton's decision. As I said yesterday, he seems to understand the law fairly well, but it's just his application of it that just seems a bit bizarre. Anyway, let's stop it there. Let's look forward to tomorrow, when we'll have a look at Wood's dissenting opinion. And yes, for Mammothon, so far the 4 guests that have agreed to come on are Fleetside, Rule Griffin, Mark Hoddenett. Obviously, be interesting to hear what his latest visits to see Stephen have been like, although obviously he can't do anything at the moment. And of course, Tracy Keogh from Australia. And I know that she's particularly keen to look at the interrogation from the under the hood point of view. Certainly, we've looked at various articles by both Richard Leo and Saul Kassan at these false confessions. They just increase. They just keep on increasing, don't they? We just keep hearing more and more about them. It really is a shame that they didn't. That the 7th arm bank didn't go in Brendan's favour, 4-3. We wonder what the 2 judges that didn't take part, what their opinions would have been, and then for SCOTUS not to have looked at Brendan's writ for certiorari. I think that would have been a good thing for them to have looked at. Certainly, Saul Kassan was actually one of the writers of the amicus briefs under the American Psychological Association. Anyway, as I said, I've kept you long enough, and I've got work to do, so I'm going to crack on and catch you tomorrow. Bye for now.